Good morning, good afternoon, or good evening, depending on where you're at. I'm your host, Bob Mata. Welcome to Defense Diaries. Oh, wait, I hear some kind of echo. Oh, it's my phone. Wow, that's amazing. That is, hold on. I was trying to share this out and I forgot the tweet to promote. All right, y'all. So I'm waiting for Allie. She's joining us. I'm super excited. My brilliant, beautiful wife should be on any moment. She's got to send me an email with we got from the clerk with all the recent orders. So I missed you guys on Delphi. It's been a hot minute. We've been busy on other stuff. We did some Adnan Syed yesterday. And it was it's interesting. There's a lot of stuff going on in the true crime world these days. A lot of stuff going on. I just did a live over at Sleuth Intuition's channel. Went well. Went well. I thought I was going to get a lot more hate over there. I'm glad I didn't. I'm glad I didn't. I actually had a very nice conversation. I thought it was productive. We don't all have to agree on things. What's up? There's my
Hi.
beautiful, brilliant co-host, Allie. What's up, girl?
So I was going to watch and then I didn't. So it went well.
It did. It did. Yeah. It was very civilized. It's very civilized. So I enjoyed it. It went longer than I thought it was going to. So Allie was a little pissed. I was supposed to give her the 20-minute warning,
Oh, yeah.
which I did not do. I instead gave her the 7-minute warning. We're like, hey, we're going live in 7 minutes. She's like, boop. So do me a favor, babe. I've got Dizzy sent me the motion in Limine. Kind of the way that I want to handle this with respect to the most recent order, which I think is what everybody really wants to talk about. I mean, like, no one's surprised that the motion to dismiss was. I think we did a live about the motion to dismiss being denied and all that stuff. Like, that was to be fully anticipated. But the most recent ruling / order from Judge Gull, I think, has people up in arms, and I'm dying to pick your brain about what you think about what's going on with this.
I think he's
And
being fully denied his constitutional right to present a defense. It's like
all righty, so there's the end of our stream. There you go, folks. That's all you need to
Oh,
hear.
you mean like you're dying once we get into it more to okay, sorry.
Yeah, I mean,
Strike that from the record.
she just really just finished the whole live in 10 seconds there. So I kid. Oh, I'm so glad you're here. I'm so glad you're here. Like, I'm lonely. No Jay, no Allie. It's like I like having company. So I'm very, very happy you're with me. And of course, I love looking at your beautiful face too. So that's always helpful. And picking your big brain. Look at the big brain on Brad. Okay. So did you email that to me? All the
Strike that does
orders?
not really mean anything, sleuthy, because they don't actually strike it. And even when the judge says, I will strike that from the record, it's usually still in the
On the
transcript.
record. Yeah.
But it does kind of have an effect because you can't rely on it in an appeal because it was stricken from the record.
All right. Okay, so what I figure we'll do, I'm going to do a refresher on the motion in Limine. So I'm going to pull that up while you're emailing me all the orders, right?
Oh, I'm sorry.
Thank you.
I was trying to send Jilly a picture of the say yes to the dress thing.
Oh, it's the day before her birthday day.
I already said that.
Okay.
Oh,
That's
yeah.
a Mata family tradition. We always wish happy day before your birthday day. That's something that we always do. People love it. They think it's just the sweetest thing ever. All right. So while you're going through that, we're going to go through.
What?
And I actually,
You
I don't
told me
know.
I didn't email to you yesterday?
I don't think so.
I usually send them as soon as I realize I have them, but
I think you were, I
on
think
my
you
way
had
to
a little
court
baby.
and
I think you had a baby on your hip.
no, I was looking at it actually on my way to court.
you couldn't put down. Like my mom was on full blown baby duty. Like I only got to spend about an hour and a half. Then I had to get back to the house because I was doing the Syed live yesterday, which I wish you would have been there for that too. I had long thoughts. I would love to hear you, but I want to do another one to kind of finish that off. You would have been. I read way too much of the opinion. Like you would have not been happy with me yesterday. You would have been like, what
If
are
the
you
people weren't
doing?
bored, then, you know,
It's hard to know. I mean, the chat's so sweet. They never tell me that they're bored.
well, if they're
So,
chatting
like,
about
God, this
something
guy's
else, then
boring the shit out of me.
if they're
Uh,
all chatting about something else, that's cue number 1.
oh, Renee, like, yeah, thank you so much for covering this. The only other channel I've seen talk about these updates. Keep saying probative, motion and Limine. Yeah, well, we appreciate you. Thank you for the financial support. We just love that. Means the world to us. So yeah, we definitely want to dig into this. And like I see people concerned with, whether or not we are still covering Delphi, and we are absolutely, I'm not going anywhere on Delphi. It's just been quiet. It's been quiet, and they're kind of in that period of time, like I like to call it the lull before the storm, as we're approaching trial very, very quickly. We're not getting a bunch of action after I was present for the 3 days of hearings. And by the way, a cherished listener, our dear friend of the show, Joe Schmo, who I got to meet live and in person when I was at those hearings, was kind enough. He actually ordered all the transcripts and was kind enough from those 3 days of hearings, and he provided them to us. I'm extremely grateful. Joe, which I did
Did
not
we
know.
check the rule, by the way, to see if you're allowed? Because was it Joe or somebody who filed a motion to prevent the court reporter from charging the original, not the copy fee on
No, that
copies?
wasn't Joe. That was
Uh,
another dude who's
but so I don't
typically.
know if technically they're allowed to be shared or not, but
I actually thought it was for as unhinged as that particular creator can be sometimes. That was actually uh that was the best thing he's done on the case so far, because he was right. He was right. Like that, it was. I don't know if there was an end result on that, but
well, how did he know that it was already prepared, that he wasn't the first that asked for it?
because I think there had been they had done the defense had filed for a precipice
Right,
for transcripts.
but the defense is getting those, but the county might be paying the court reporter, because those are he doesn't have to pay for his.
Well, it wasn't even so much that, it was that they were gouging. It was like
Right.
massive price gouging. It was insane.
Alright, sorry, I got us completely off topic. So you were saying
Okay.
about Joe Schmo and how amazing he is. Oh, that he gave us the transcripts,
He
and
gave
that's
us all the
where
transcripts of what he ordered. And also Dizzy made me aware that Joe Schmo has his own YouTube channel. He's got a little baby YouTube channel that he is trying to grow. So as we do with all friends of the show, we will be dropping his link over there. And we fully expect all of the fam to go over there and sub. And if you guys are new to our channel, please remember to like, share, subscribe. That really, really helps our channel out. And we're super appreciative of it. I got super depressed today. Like Viv, our one of our ride or dies member of the fam, she tweeted today. She's like, I've been depressed because like a lot of people are missing Jay. And she's
Hmm,
like, I was like, wait, I'm like the chat's basically the same. Like we have almost the same chat. I'm like, but like we all miss Jay. So
right.
I felt sad too. I'm like, man, yeah, I do miss Jay. So
Who
like I don't
couldn't
want
miss
to make him
Jay?
feel bad though. Like he's doing what he has to do. So um and he's still gonna be here at nights. We're still gonna get to hang with Jay. So but Viv, just remember we've got a lot of the fam over here. A lot of JBN was we've got Armada and JBNs that are both fams. Jay and I always consider it a collective fam. All right. So I just want to make sure that Viv hears that because I love her and she's an amazing human. Okay, so let's go through the motion in limine. So the most recent filing, or strike that, the most recent order that came down from Gull was the one that we were really all waiting for. And kind of the thing that everybody was losing their mind about, which was the third party culprit stuff, was the least of my concerns. I was far more concerned about what we're going to get into, which is the geofencing data somehow being excluded, which I just don't get. Because if you guys know, if you've been watching me, I've been calling for an attack on the timeline. And oh, good. Thank you for that. Jay is on tonight. I will make sure that I am portaling everybody to my brother's show tonight. Remind me to do that, Dizzy, before I get off, please. Oh, thank you, Trendy Views. Thank you, thank you, thank you. Yeah, let's show Joe what we can do over here. Okay, so but like to me, the geofencing thing just blew my mind. I just think that they don't need to lean into the third party thing as much because they have such a solid attack on the timeline based on what I know, based on the fact that I like in those hearings, I heard definitively that they didn't take the body temperature of the girls, and like that's a problem.
So I just want to
And it,
mention that, sorry, babe,
oh no, go ahead. I was basically done.
that this is part of the downside of putting your whole case before the state ahead of time.
That's
Because
right.
I have never seen something like, now this motion in lemonade doesn't say, at least, sorry, I don't think so, right? That they can't put on, quote, like third party evidence relating to this. My understanding, and I haven't read it in a while, is like they cannot mention the words. They cannot talk about X, Y, and Z. And that is the most absurd thing I ever heard. Now, for those of you who were following the Tellez, because he likes to hide his Hispanic background for some reason, um, trial, they didn't have to do some special motion to talk about this other guy who they did not know, who was seen by somebody in the area at the same time, who looked similar and was wearing the same outfit. This is not something that happens. Like, you can't mention it. And turning, like, for something I'm sure everybody here probably knows, the Karen Reed trial, they weren't allowed to put on like certain third party culprit evidence, but that did not stop them one iota from talking about the lack of investigation and the other potential leads that existed. Whether or not they were allowed to put it full forth as third party culprit and get in additional evidence that you might otherwise not be able to get in, that doesn't change that you can't mention the fact that they exist. And she granted everything, right? Every single solitary.
Yeah, we're gonna like. Did you send me the order? Because we're gonna go through the motion limine,
Oh,
and then
oh,
we'll cross reference
I
the
sent you
order
all the
between.
orders, but I should have mentioned which was which. So let me just actually, I
Oh,
think,
thanks. We love our merch too. And by the way, uh I just like Phil Toyo Toys had asked for an update. I had ordered because I had volunteered to donate a DD t-shirt for the winner of Tea's bingo. And I just wanted to let our winner know that I have placed the order. We go through bonfire right now. I'm looking to change
my
using.
sister's, fiance said
I
he would.
talked to Mike at length. It's not as easy as you think.
But your merch is coming, people.
Your merch is coming, so I just wanted to let the winner know. I don't know if she wants me giving her name out, but she knows who she is. I ordered it. It's on demand, so it takes a little bit longer. But I just wanted to give assurances if if she happens to be watching, that we in fact are. I put the order in. You should get the shirt hopefully soon. hopefully soon. So, and I hope that you enjoy it. It's a good one. It's a good one. All right, guys. So, like I said, what we're going to do first is we're going to review the motion in limine. And a motion in limine is a motion that is typically filed just prior to trial, and it typically is dealing with specific things that either side doesn't want said or introduced into evidence. Okay, and then they want the judge to make a ruling on that. So a lot of these actually were dealt with in court, like right when she got on the bench on day one. I think it was day one. It might have been day three, where she's like I was reading this and I was like, do I seriously have to rule on like you guys not talking shit to each other like at trial? Like, do I really need to rule on that? And they were all like, no, we'll behave. But so starting with the first one. So
Well, but
now,
don't forget at the top how it says it's not gonna be requested, it's not gonna be mentioned in the presence of the jury during voir dire, opening, closings, and now go.
yes.
Directly
Uh,
or indirectly.
hey, what's up, Lana? Yes, I am definitely attending the trial. I feel it's more important now than ever that I'm at the trial. Like now I really need to be watchdogging what the hell's going on in that trial. Okay, so now comes the state of Indiana by prosecuting
Oh.
attorney Nicholas McClelland and respectfully requests that the court enter an order required the defendant or his counsels to refrain from mentioning in the presence of the jury during voir dire, opening argument, presentation of evidence, and closing argument any and all references to the following, either directly or indirectly. So every stage of the trial,
And directly or indirectly.
like even like by accident.
I mean, indirectly
You
could
can't even
mean
mention a dude named
you can't even
Brad
mention
that's
there's
not
blood
Brad
on the
Holden.
tree. Can you mention that there's blood on a tree?
I mean, all right. Okay, so number one, any comments about counsel for the state that constitutes a personal attack on the attorney for the state or comments on the role of the state's attorney. So, like, that is not a motion in limine. Like, I've never heard of anything like that. It was just weird. And I'm not gonna even get into it.
It was granted.
Granted, well, no, like that's what I'm saying. They like for these, they all agreed that they
She
weren't gonna
put
do
1
any
through
of.
7, 1 through
I
6.
know, I
So
know, I know.
that's 1.
So two, any comment in which constitutes the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. Okay, for instance, defense counsel cannot vouch for the truthfulness or competency of any state's witness, including police officers or his own witnesses. I know Todd Click. I know
So
Kevin Murphy. They're great cops.
I mentioned this when we did this motion originally. It looks like they took a defense motion and just tried to file it for as a prosecution motion, because that is something we typically say they're not allowed to do with their, police witnesses,
Right.
and that they
Exactly.
can't mention, they
Yeah, you
can't
can't like
demean the
improper
defendants.
bolstering. Yeah, it's called improper bolstering. You can't like technically like when we all watched.
Can I ask you something? When would the defense ever vouch for the truthfulness or competency of a state witness? I mean,
Never.
it's like they
I mean,
literally
well,
copied and pasted this, and this was a defense
yeah.
motion that
I mean,
somebody.
the cop thing makes sense because of Click Ferency and
Correct, but they
Murphy,
wrote the
obviously.
words of any of the state's witnesses,
Right. I mean, typically you're
including
not. Typically, I mean, maybe there's crossover. I guess there could be a situation. I don't know.
whatever. No.
Whatever. Yeah. Rejected. Okay. Three. Any innuendo or inference that is not supported by admissible evidence.
Can't believe she granted that. It's vague. It doesn't mean anything. That's not the way this works. A specific thing is that they have to ask for, not anything unsupported by admissible evidence. And the fact that she granted it is just ridiculous because you can't even enforce it.
Yeah. It's just like he wrote words in paragraph 3 and she granted it. It's weird. Attorney cannot assert. I mean, doesn't she realize that a circumstantial case is inference?
All right, so then is she granting it as to the defense? They can't make any inferences. They can't draw any inferences. They can't They gotta be like literally, you know,
Well, the state, like by way of this, the state can't argue a circumstantial case because you have to make inferences when using circumstantial evidence in terms of proving a case. It's 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 an inference that you're
right,
making based
but
on the
they're
evidence. The next logical
supposedly
leap.
supported
It's a
by
weird.
admissible evidence.
Yeah,
Those
it's a
inferences are supported by admissible evidence, but it is often a complaint we make against the prosecution. I'm doing it right now in a motion that they argued innuendos and inferences that were completely unsupported by the record and that they had no factual basis to argue to the jury.
yeah.
This is not something that usually is applicable to the defense. Anyway, it's vague, it's stupid, it shouldn't have been written
Is that your
or
legal argument?
granted. That is my legal argument.
Vague and stupid. I like that. That's a
Motions
good.
in limine are to deal with what they finally do in 7, a specific thing that you want excluded
Right.
or
All right.
included.
Okay, so 4 was any attempt to indoctrinate the jury during voir dire by exposing the jury to substantive issues in the case.
Not supposed to do it anyway.
Not supposed to do it anyway. Like it's just like these are things that immediately you object to and are going to be sustained
But
if it
sometimes you
happens.
can. Like, for example, would hearing, harm coming to a child be something that you can handle? I mean, so again, this should never have been granted. It should never been asked.
Yeah, in cases like sometimes in DV cases, you know, you can ask questions about whether or not people were victims of domestic violence or friends or
Always,
family.
always.
Right. So I mean that and
Don't use that.
technically you're indoctrinating the jury a little bit because that's what the basis of the case is. But all right. 5, any attempt during voir dire to have the jury prejudge the credibility of a witness. So that would have shut you down. That would have, I don't know where she went. Where'd you go? Where's she at? See, I read for 1 second, she vanishes. She vanishes. So one of Allie's favorite areas, actually both of us, but Allie really loves during voir dire to ask jurors, potential jurors, about police officers, and just by way of the fact that they have a badge and they wear a uniform, are the jurors more inclined to find them more credible, more believable? And it's a fair question. It's a question that should be asked, and it's a so I was going through this one. Where'd you go?
Yeah, I heard you. Your dad was
Oh,
coming through.
all right. So
But yeah, that's exactly I heard what you were saying. That's exactly right. It is
crazy.
irrelevant. It is always allowed. It's never an issue. And again, they're not even being specific as to what witness are they asking them to prejudge. Like you just said, that is the a number one question. Like even if there's certain times the judge will ask you, do you want me to cover the top, the top 4, which would be like the defendant not having to testify, that the burden of proof always remaining on the state, and that they should give no more weight to a police officer's testimony than they would a regular person. So I don't know what they're getting at.
I don't know. I like in Sleuthy, I see what you're saying, that but they only asked for these for the defense. But at the hearing when she addressed these first 5 or 6, they apply to both sides. Okay, so 6, any hypothetical question that includes facts that are not in evidence or questions that are not helpful in violation of
Which
Rule 705.
again, you're not allowed to do. So we didn't need a
Right.
motion.
Right. All right. Now we're getting to some actual motion and limine stuff. Okay, so 7, any attempt to introduce third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. That's Rule of Evidence 401. Before any such evidence may be permitted, defense must show some connection between the third party and the crime. And then cites Holmes v. South Carolina. Further, it must be a direct connection based on admissible evidence and not found in hearsay, speculation, rumors, conjecture, or theory. Okay. And then he cites McIntyre v. State, Magaha v. State, and Tibbs v. State. And then the state requests such order to eliminate to include, but not limited to, the following: Odinism, cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Jerry Klein, and Ron Logan. All right. 8, which is directly connected to 7. Any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Todd Click that is not relevant or is used for the purpose or of confusing the issues or has the potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it's relevant. Mullins v. State. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Rolston v. State. Evidence may be excluded if it confuses the issues. And then here's where it gets crazy. So any reference, 9 is any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings from any geofence search that is not relevant or is for the purposes of confusing the issues or has the potential to mislead the jury. Mislead the jury from what? That maybe Rick Allen wasn't the only guy out there?
All right, but it also says that is not relevant. So, I mean, okay, you can never put in anything that's not relevant. So he's saying,
How could Gull ever find that if there were now, like, because this goes to weight, not admissibility to me, when they put the experts on about geofencing in terms of how reliable it is, especially in Indiana. Indiana, like I said, does not follow hardcore Fry or Daubert. They just don't. So like they just look at it as everything is it goes to weight, not admissibility. It's not an issue of whether we're going to allow it in. It's an issue for the jury to decide how much weight they're going to afford that particular piece of evidence. So for me, how can the concept that there are 3 or 4 other phones that are thought to have been potentially could have been on or around Ron Logan's property at the time that the killings took place not be relevant? I mean, are we not,
insane.
is the search for the truth of what really happened here not at all a factor in this trial? Like that, like, I mean, does no one give a shit about the truth, whether it's Rick Allen or not? Like, I want to feel comfortable. I want to feel secure in any conviction that they have the right person. And when she's not allowing this kind of stuff to come in, like 9, her keeping that out blew my mind way more than the third party. But that was selfish because of the way that I've been talking about this for the last 2 months is quit leaning into the third party stuff. You're never going to be able to put those dudes near the bridge. If Click, Ferenczi, and Murphy couldn't do it, Matt Hoffman and his limited ability to be able to access things that regular law enforcement and the feds are, he's not going to be able to do it. I'm like, focus. That's why I've been saying, focus all your attention. Find a civilian that is going to be able to say that the girls were not on that property at the time that they were searching from 5:30 until midnight. That is devastating evidence. That blows apart the state's timeline. I've said it a million times. Quit focusing on the third party thing. Like, what you have there is what you have there. No matter how many times Adney puts it out there, nothing changes with it. Just nothing changes with it. It's like, it's the same thing. Do I think that there's something there? Yeah. Do I think that there is a nexus? Absolutely. Do I think that Elvis Fields saying that, like, even if he poses it as a speculative question, as a what if, as a hypothetical, what if I spit on one of the girls, but I had a reason as to why I did it, would I still be in trouble? Like, that's a nexus to me. It's like the fact is that Holder's putting these images that apparently seem to mimic crimes, the actual crime scene, is a nexus to me. The fact that Brad Holder's son is dating one of the girls, and I put air quotes with dating, but was, whatever young teenage kids do, that there's a direct connection between Holder and that, it's like there's nexuses there. I mean, like if like it seems to me that what Gull is requiring is that they have enough admissible evidence so that law enforcement actually could have arrested them. If you don't think, because I posed this question to Sleuth when I was on his show, I said, like, with everything that we know about Holder and Westfall, especially in Fields, tangentially, but with those two guys, and Westfall lives in Delphi, so you can place him in Delphi. But if law enforcement had been able to place those guys near the bridge through their phones, would they have been placed under arrest based on everything else we have? And I think that the answer is yes, they would have. I think that they would have arrested them. I really do. So, what she's suggesting is that they have to have enough evidence that law enforcement should have and could have arrested that third party culprit that you're putting forth. Like, there's no other way to take her ruling, is that the bar in Judge Gull's court is that you essentially have to solve the case as to a third culprit in order to be able to bring it into court and argue it. I don't know how else you can view her ruling, which is obscene. Like, if the cops had placed them there, they would have been under arrest. So you don't have a third party culprit because they are the culprits. They're the ones at trial. Doesn't make any sense to me. All right. Am I crazy on that?
No.
All right. So 10, any reference to any prior bad acts or acts of any witnesses that plan to testify at the trial that is not relevant to what the defendant is on trial for, that is not an act, that is an exception to Indiana Rules of Evidence 404B, and that is not both relevant under Indiana Rules of Evidence 401 and tend to negate the guilt of the defendant. So what do you think that means? I mean,
Yes.
I know what 404B means in general. What is he talking about?
Sorry, I popped over to look at the appeal, interlocutory appeal as a matter of right. I mean, as for the defendant, and I
Aw,
lost you.
family hug. Oh, and I was supposed to give Joe Schmo a family hug. Aw, family hug,
Oh, I
Joe
think I
Schmo.
found you. No, I still didn't find you. I've got too many windows open and I can't find
Renee,
share.
I mean, if you're asking if they're going to file
Oh,
another
found it.
original action, no, they're not going to file another original action. The only question that exists is not an OA, in my opinion. In my opinion, is
Interlocutory
whether
appeal
or not they can file an interlocutory appeal, which Judge
requires
Gull has to
right,
certify.
right.
Okay, that means Gull has
That's
to
what I was just
approve.
re-looking at right just now when I lost you. So you were asking about 10 or 11.
10. So I'm going to reread it.
I s
Any reference? Do you not need me to reread it? You just want to
No,
read it?
so that's really where the requirement comes in, of third party culprits, like whether you can put in a bad act technically, that's something that doesn't fall under, 404B because, like here, if they had the act of, um, and I don't know if it's technically bad or not, but the prior act of whoever they were saying was one of the potential third party culprits of doing something similar or marking a tree or holding a thing in court, going out in the woods, but you can't impeach. You can impeach the credibility of a witness with anything, but not usually with crimes or other bad acts unless it's either dealing with honesty. All right, hold on a sec.
Oh, she's gone. All right.
I'm dealing with your dad.
Oh, all right. I'm gonna read 11 while you're dealing with Papa Mata. All right. So any reference to how the files were labeled that were handed over to the defense as part of the information and discovery provided to the defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. The burden is on the opponent to show why it's relevant. Relevant evidence may be excluded if its probative value is substantially outweighed. He gives the same 3 citations for every single one of these things. Okay.
They would have had no reason to put something like that in.
It's bizarre.
Unless I'm assuming there's something that they have referenced in their shit. Like, well, they even gave us a file that was called ritualistic killings, you know what I mean? Or whatever, Odinism.
Well,
So there
I
must
mean,
have been something specific that the defense alluded to that's why they put that in there.
they have been arguing that, when they retendered the discovery over to the defense, that it was a hot mess, and that they can't make heads from tails. And then, that's when you have, and they had filed their motion to compel, the defense had filed their motion to compel saying they didn't have X, Y, and Z. And then at the hearing, like when they took a break, McClellan ran down to his office. Like, he's like, I know we turned this over to him, like hopped on his computer, printed out an email with a discovery receipt and said, here, your honor, like handed a copy to O'Shea, who was handling that argument. And she's like, oh, this is so kind of Mr. McClellan to go down to his office and print this out that they had turned it over. And McClellan's like, well, I wanted to print that out just to show that we are tendering these things to them, that they have them in their possession, yet they continue to say that we haven't turned them over. So, I mean, it's relating to that. Like they're like, he's arguing that he doesn't want the defense to be able to give the needle in the haystack argument to the jury while in the middle of trial that, oh, well, yeah, they may have given us all the evidence, but it's such a hot mess that we couldn't, like, we didn't have time. Like the
They
defense
wouldn't be
isn't making
arguing
that
that
argument.
anyway. Right. I
Right.
think there's something else, something about how they actually labeled things that they thought the defense could somehow use to their benefit. But that's the precise reason that you don't grant things like this, where they're just asking for like vague, random, stuff.
Yeah. Brandy, that's what the interlocutory appeal that we're talking about is. Um, so the question, like, so the way that interlocutory appeal is just an appeal that's happening while the trial is pending. Okay. So, like, where you get your direct appeal is after a conviction has been entered, interlocutory appeal, but there's very specific things that you can appeal interlocutory style. And beyond that, they have to get Gull to certify, meaning approve the issue to go up. I mean, what if it's you and I would have to think that we would take a shot at it, depending on how adamant you are about the third party culprit stuff. Like, to me, like, I'd be saying, okay, third party culprit, but definitely I want to file an interlocutory. Like, I don't know how she's keeping this geofencing shit out. It's huge to me. Huge. Like, it's like it's potentially got 3 or 4 other individuals on the property. Like get the experts up there. Let's hear what the experts have to say. Like at this point in time, all she has is Nick McClellan saying that Carroll County does not trust geofencing. Geofencing is inherently unreliable because it's got such a huge range, and that frankly, those 3 people that are showing up on that property could have been anywhere in Delphi. And that's what she's basing her ruling on. There was no expert coming on and testifying unless I fell asleep when I was in the courtroom those 3 days. Like, it just drifted off into a coma-like sleep and missed some expert coming up, and he's like, we won't even use it. Our office won't even use it to secure warrants. That's how unreliable it is. And apparently that convinced Gull to keep it out entirely. That's what I'd be trying to get up on interlocutory appeal, because that is devastating to me.
Well, they've got like I'm looking in the notes of decisions on appeals by defendant that are allowed by a defendant, and like one case in 1984 says rulings on rulings on motions in limine are not reviewable on appeal. 1984 interlocutory, and then another case interlocutory appeals from denial of pretrial motions such as motions in limine, motions to suppress, etc., are not allowed. 1984. But then there's this one from 1992 that says appeal of denial of a motion to suppress could not be taken as a matter of right, although appeal would be entertained if order was properly certified by the trial court and accepted by the reviewing court. So, obviously it has to be either way. We knew it had to be, accepted by, approved by Gull, and then the appellate court decides whether they're going to take it. And the defendant's request for continuance to prepare a defense did not forfeit right of review. Okay, that was on a bond issue. I was just trying to see if there was anything about your right to, the continuance and your right to review if trials set. That's all it's
Yeah.
got.
All right, so I saw a couple more questions. I want to try to be a little more thorough on this, and of course we're guessing. But as to 10, with respect to the prior bad acts, I think that this was written in addition to paragraph 7, in the event that she was allowing some of the bad actors in the defense's mind, the Westfalls, the Holders, if she was going to allow any of those guys to be called, who were certainly, I believe, going to be on the witness list for the defense, that's who they're referring to, that they were not going to allow the defense to bring up their prior bad acts, anything that could be construed as bad acts by any of those actors. That's who I think that they're talking about, if I had to guess. So I think that was just like an extra layer of coverage for McClelland in the event that she was going to allow some of the third party culprit stuff to come in, that they wouldn't be able to take it a step further and start showing these guys are violent dudes, because there is stuff out there, like we got the thing with Johnny Messer, that he kidnapped somebody at gunpoint.
And that's the kind of thing that a third party culprit finding allows you to do where it otherwise wouldn't. You have to rise to a certain level of them finding that you've got enough here to show that this person, well, no, sorry, I take it back. It would still have had to be something that could go towards, you couldn't put it in just to show they're violent, but you could put it in if it went to motive, means, opportunity, the same things that you can do for, for a defendant, where if they're just testifying, you could never get that stuff in because you're not also accusing them of a crime. So, but it's different than just saying you can't mention this person's name. You can't talk about how the police investigated him, but that, but there wasn't any further follow-up, that you can't imply that this person may have done something without needing all the other stuff that you would need if they found specifically that they were, a third party culprit. But go ahead. Sorry.
But why are you apologizing? You never need to apologize for me, for you talking. People love hearing you. I was actually, like Taryn had said, look up the Fifth Circuit Court's ruling on geofencing. Tell me what it is. I was going to try to take a peek at it, Taryn.
I'll look while you're reading.
Okay. So I hope that answers the question on 10. So 12, any reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation into the murder of Abigail Williams and Liberty German, that are not relevant or would tend to cause confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. And then he cites the same 3 cases again. So I don't know what the hell he's talking about. Sleuthy, do you know what he's talking about there? Like, if anybody knows, these PowerPoints. It's going to be Sleuthy if she's still in here.
Yeah, no, I know what they're talking about. They're talking about where they thought it was. Now I don't get the people wrong. Did they think it was Lowe or did they think it was the other guy? Whichever guy that they thought it was, they put this whole PowerPoint together about how it looked like him, and it, like the Fed said, I can't say for certain, but all this points to it being this guy, whichever that other guy was.
Wait, are we talking about? Wait, so Sleuthy's saying the PowerPoint's about Messer.
Oh, was Messer the one who looked like the picture?
Wait, are you talking about the composites, the sketches?
Yeah, I thought they also did some sort of PowerPoint for that, so disregard.
Okay. All right. Yeah. Like, I mean, Sleuthy's going to know. Dane Paul, $5 holla. Appreciate you. Dane Paul, helps if you write something. Does Indiana allow a motion for particulars? And what does that give you? So I'm assuming that you're talking about a bill of particulars.
Yeah, a motion for a bill of particulars is like if they're accusing you of a crime and geez, did you hear that ringing or did it just play in my ears? I guess you didn't hear it. Right? Can you hear me? Oh, he left. All right. Sorry, guys. So anyway, a bill of particulars is like you want to know specifically what the crime is that they're accusing you of, what time it was or what date it was, or if they're using something vague. Like a lot of times you can just put the language of the statute. So for instance, I had a case once where it was something I think about interfering with an officer while they were you know, investigating a crime or doing their official duties, interfering with the official duties of an officer. And I wanted them to give me specifically what it was the person did because they had a bunch of different stuff and some of it might not even have fell into that specific, offense. So things like that. And it makes them be very specific about what it is they're alleging happened, and where. And if they, for example, did included a range, which doesn't usually happen unless it's a sex offense, against a child, because obviously children aren't expected to remember the precise date that something happened to them. Then you'd ask for a bill of particulars there. Here, there wouldn't be anything to ask a bill of particulars for. Now, maybe prior when they were, and I can't remember now that Bob's gone, if it's still, they have this as the kidnapping, or they dismissed the kidnapping and they just charged him directly with the murder. You might have been able to ask for a bill of particulars of, how it is they're saying the kidnapping facilitated the murder or something like that. But it's not something that would really come into play here, assuming that's what you're asking about. Yeah, that's not something that they ever ask the jury about, whether or not they're confused. The judge just makes that determination on their own. And then Sleuthy gave me some details about the PowerPoint. And this is in a defense filing, is what I'm assuming based on the rest of what I'm reading. But it says, find attached information on Johnny Messer provided to defense and discovery. This information appears to have been made for a PowerPoint presentation and features Messer's photograph and other information, including that Messer was on home detention for a January 2018 meth arrest. This document is marked as Exhibit 66. So, yes, they were talking about a PowerPoint that dealt with Messer. So, this is the kind of thing, like I'm saying, if you don't put everything out there to the defense, then to the state, then they don't have some way to, be prepared to attack everything specifically, and to go through and pick which are the most compelling things that they want to exclude. If they don't know where you're going specifically with it, they don't know how you are going to tie it together in closing. They don't see it right then when it happens as something that they should be, asking to exclude. So, I mean, like I said, that's one of the reasons why, as the defense, I never want to tell the state anything about where I'm going. I want to keep as many things close to the chest as I can, but or close to the vest.
Both are accurate. I use close to the vest because it comes from like poker players back in the cowboy days when they used to hold their.
Right, I
They used
like
to wear the
close to the vest. That's why I didn't know why I used chest right there. So, um, given the nature of the crime, wouldn't you expect, yes, a digital footprint history suggesting, yes, predilection like this? Yes. Did they find anything? No. And that's like one of the main things that I'm surprised they didn't tell them they can't argue the lack of evidence as
Yeah. You can't argue that the fact that Richard Allen's never done anything criminal or even remotely criminal, or there's no link to, any kind of weird shit on any of his devices can't be mentioned. It's like,
and it's not something they really have been putting out there, how this speaks to, at least or did they? They did actually in the motion to
oh yeah,
quash.
no, they've put it out there.
Oh, so
I'll
the
always remember it.
prosecution didn't want to exclude that.
I think it was paragraph 6 of the original Franks was talking about that they found no evidence. But a lot of it was relating to no connection to Odinism or like
Can you
that
hear
one.
the ding when it like, I just got a
No,
ding? Okay, good.
uh-uh,
All right.
no.
Y
I can't hear any any kind of
The
strange sound.
ringings or all right, cool.
Oh, thank you, Dawn. Yeah, so babe, my new Shure, the one that I picked up. You see this little bar here?
Mhm.
So I forgot that it's a touch thing.
Oh.
So yesterday I picked it up and I was in the middle, like I moved the mic. I didn't realize I touched it and I forgot about it. And I was reading for about 5 minutes muted. And of course, when I'm reading, I'm not
You're
looking at
not
the
looking at
chat.
the chat.
Izzy's
Right.
texting me. She's like, "You're muted, idiot." And like people in the chat, like, and then finally Dawn throws a $10 holla, which Dizzy throws up on the screen. So I saw it and I'm like, oh my God. I'm like, so how long was I
They had
muted?
to
20
pay
minutes?
you to unmute you. Wow.
I
Thanks,
know.
Don. Thanks, Don.
It's quite a move. Like I'm gonna remember that one in the future.
And Dizzy's asking, Bob, did you download the app that was recommended?
What app?
So you guys have to
Refresh my
discuss that
recollection.
longer
What app?
later.
Okay. Tell me
So,
what
and I
app.
just read, by the way, while you were gone, that Sleuthy sent over a footnote. That's how I got in this discussion about the defense putting everything
Rude.
out there. A footnote about that being the Messer PowerPoint.
Okay.
All right, I labeled it when I emailed it to you. Ruling on motion in limine.
Oh yeah, I got it. I got it ready. Boop. There we go. Okay. So here is the companion piece to the motion limine. Judge Gull's order, which came down yesterday. And I think it was yesterday. Was it yesterday or was it? It had to have been yesterday, right? Today's Wednesday. Say
No,
Thursday. Might have been Tuesday. I don't know. Every day.
the email came yesterday and it's dated 9/4. So yeah, yesterday.
Okay. All right. So, and if y'all want me to kind of flip back and forth between the motion eliminate for reference, just let me know in the chat. But
I think they're fine because we all know the only thing she speaks separately is 7. And we all remember which 7 is.
yeah,
All of
sure
the
do.
others, she just bulks together and says granted.
Right. Okay. So the court, having had the state's motion eliminate under advisement following a hearing conducted on August 1 of 2024, and having heard and considered the evidence, admitted exhibits, arguments of counsel, defendant's supplemental submission regarding state's motion in limine, filed
Right.
August 13th, 2024, and the state's response to defendant's memorandum of law, filed August 26, 2024, grants paragraphs 1 through 6 over defendant's objection. I don't really think they objected. Like, that's what I'm saying. Like,
Yes, they objected. Oh, 1 through 6.
1 through 6. And grants paragraphs 8 through 12 over defendant's objection. As it relates to paragraph 7, the burden is on the defendant to show a nexus between Odinism, cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Kagan Klein, Jerry Klein, and Ron Logan, and the murders of the 2 victims. Case law is quite clear that the nexus must not be based on speculation, conjecture, rumors, or hearsay, but rather on admissible evidence. So while I'm here in this with this hearsay question, can you think of a situation in which a third-party culprit defense is being put forth that they can get Elvis Fields' statement to Murphy in? Like, what exception could that be?
Statement against interest.
Yeah, but like, even
No,
if
was
it's
that a
even if it's
party?
an if, yeah, statement of a party opponent.
That's different. Statement against interest. Yeah. It's definitely a statement against interest, even though it has if, because it shows that you think that it's gonna be there, or else why would you ask the question?
Yeah, I mean, like, I could see them making a. It's like it's almost like a hypothetical. See, the problem with that is that Kevin Murphy wasn't recording that,
It's
and
it's
I've heard.
documented in a police report.
Yeah, and I've heard various versions of it. Like, I think in the 2 days that Kevin Murphy testified, there was a slight variation in what he said that he said. You know what I mean? Like, it wasn't identical both days. So I don't know. Okay. The court finds the defense has failed to produce admissible evidence demonstrating a nexus between Odinism, cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Kagan Klein, Jerry Klein, or Ron Logan, and the murders. Therefore, court grants paragraph 7 of the state's motion in limine over defendant's objection.
So here's the other thing. They can show this nexus, this connection to the state with inadmissible evidence. I mean, to the judge with inadmissible evidence, just to get her to realize that there's enough of a connection to get in admissible evidence. Like, because that same, you know, level doesn't have to necessarily be demonstrated to the jury. It has to be proven in the mind of the judge so that she allows you to put on evidence that you hope from which the jury will infer a connection enough to raise reasonable doubt.
Well, so R. Irwin brings this up. Statement against interest if the defense can show that they made a good faith effort to subpoena Elvis but couldn't find him.
No,
Um,
you've got
I-
to be
is,
able to.
is that is that declarant unavailable? Does that fall under declarant unavailable?
I don't know.
Unavailability of the witness? I don't think so either. Yeah, and look, even if they did subpoena Elvis Fields, and he's like, hearsay is any statement that has been made out of court.
Right, but you can ask him,
You
were
you
you
can
concerned that if about them finding your saliva on the body? No, I was
Right.
not. Well, did you have a discussion and an interview with this officer at this time? Yes, I did. And do you recall discussing whether or not you had that belief? Yes, no, I don't. Would anything refresh your memory? Blah blah blah. They did the same thing in
Right. And well,
what trial were
this
we
is
watching?
the proper question. What would have been the reason that you would have been concerned?
Right, but if he said no, I wasn't concerned. I was trying to get to,
Right.
then it would be to impeach him on
Yeah, and
that.
they did depose him, and I think it was Denial City. He denied everything in the dep.
He denied having said that or having thought that?
They didn't argue it that he
Made
claimed
any
that he
admission?
said it. Yeah. So I don't know. All right.
See,
So
so
the
then you
court,
also have the issue of when you do these depositions that now you can't call a witness who you, for the purposes of impeaching them, and then you're gonna put someone on who's gonna say you didn't say it, so you're putting it on to impeach him when he doesn't say it.
I think that Fields did as well, Sleuth. I don't I don't think that he made any admissions. I think he denied being there, denied saying any of that shit. So I don't they didn't argue it. Like Baldwin didn't argue it. So I don't know. All right. So
I mean, I'm assuming they would have been asking other questions about, like, where he was and what he was doing, not about whether or not you actually committed the crime, but I don't know.
yeah, because they can't really say that the guy was at home. Like his phone, like people can leave their phones at home if they're not morons, and you're not going to know where they're at. That's kind of the
So where
entire
did
point.
you end off that in reading?
Here down at the bottom. So the court will not permit the evidence submitted by the defense in support of their arguments regarding third-party perpetrators in the trial of this cause, as the probative value of such evidence is greatly outweighed by confusion of the issues and its potential to mislead the jury. That language just stuns me. The court will allow that evidence to support an offer of proof at the trial if one is made by counsel. Well, gee,
I mean, I would
thanks,
hope she
Judge.
would just allow them to use that as their offer of proof without having to do it again, but they might
And,
wanna do it again. They might have felt they left some stuff out.
and she gives no rationale on
For the
the
1 through for 8 through 9.
right, nothing.
She doesn't even say what I mean, that right there is a reason that they could appeal it.
I mean, nothing.
1 through 6, she didn't need to really give a reason because it wasn't real.
Right. That was all like no one gives a shit about that stuff.
But 8 through
Um,
12 were.
yeah. All right. So did you have any luck with uh finding anything out about interlocutory appeals in
Just that
Indiana?
it just that it needs to be, you know,
Certified?
yeah, she's gotta give it. They I think you have one as a matter of right for bail, but that's it. Oh, I was looking at the geofencing stuff. That's where I was, but I was trying to look at what because I researched all of this, you know oh, go back to the geofencing.
Let's see.
There's nothing in mm, geofencing.
Did you look at
Admissible,
the Fifth Circuit?
unreliable. All I tried right now was geofencing in the same paragraph as admissible, um, reliable, unreliable, admit, and inadmissible. So I don't know. And I got nada, not one case. Maybe geofencing has got a dash. Maybe it's 2 words. Nothing. What
All right.
5th
So
Circuit case did
yeah,
she
I
give you?
pulled up like Taryn, give us a case citation. Like just saying, look it up in the if you have a case, even if it's
I'll
just the
just go
parties
to the 5th Circuit and put in the word. I'll just maybe
geofencing. Yeah.
I mean,
So our Irwin threw in here. So 803 is exceptions. So those are hearsay exceptions. So there's non-hearsay and then hearsay exceptions to the rule against hearsay, regardless of whether the declarant is available as a witness. So our
oh, there
Irwin
was
is
a
thinking,
2024 5th Circuit. Is that the case she's talking about?
I don't know.
Well, she's still
Is that
here.
she's still here?
Alright, I'll look at it.
All right. So
No, that's talking about, uh, you having a right to
Okay.
privacy in your location.
So, the way that the rule goes, Erwin, is it's like 803, and then it's 1, 2, 3, 4. So 1 is present sense impression, excited utterance is 2. 3 is then existing mental, emotional, physical condition, and then 4 is statement made for medical diagnosis or treatment. And then under 4, 5, and 6, 7, 8, then they have A through B. So clarify it a little more which one you're thinking. I mean, you can make an argument present sense impression, maybe, or 803. I don't know that it would qualify as an excited utterance. We're talking about field statement.
I mean, if he was crying at the time.
I don't think he was crying. I don't think he was crying. So declarant unavailable. So I think you're talking about 804. So 804A criteria for being unavailable. Declarant is considered to be unavailable as a witness if the declarant is exempted from testifying about the subject matter of the declarant statement because the court rules that a privilege applies. A2 is refuses to testify about the subject matter despite a court order to do so. 3 testifies not remembering the subject matter.
Right.
4 cannot be present or testify at trial or hearing because of death or then existing infirmity,
Right. So
physical illness, or
so
mental
that's what
illness.
they're saying, that the courts kind of consider you unavailable when you say you forget. That's why I was like, if he said, he forgot saying that, you know.
Yeah.
So, by the way, there's this August 9th, 2024 Fifth Circuit case where
Yeah, I got you. R1.
where they're talking about the reliability of um wait. Hmm? So the head note says district court did not abuse its discretion in robbery prosecution when it admitted testimony of a government's expert regarding wireless carriers' cell site location information and cell phone users' location history. Location history was collected of data that was itself derived from a combination of 3 forms of geolocation. CLSI, which is cell site location information, GPS, and wireless network. And the expert's extensive knowledge, skill, experience, training, and education in those historically reliable forms of geolocation allowed him to discuss location history data. So,
I
you know
think
why? Because they
so.
call it
R. Irwin was talking about
geolocation, not geofencing. Is is
geolocation is different than geofencing.
what?
Aren't those 2 different things? Geolocation is like like we're geolocated all the time on our phones. Geofencing is a very specific thing that Google created. Like, remember, they created geofencing in order to to for sales. So like if you had a vendor or like say a store and you walk through like a geofenced area, like if you're in the mall and you are walking by, like, would name a store in a mall, whatever, like Spencer's Gifts, and they're like, oh, you're walking by, and it's like, oh, Spencer's Gifts pops on your phone. We have a 10% off on any, like ugly Christmas sweater that you want to buy or whatever. That's how geofencing. That's how it was developed, so that when you crossed into a certain area that was near a place that was, a place of business that wanted to be able to draw you into their business, it would pop up on your phone and say, "Oh, like you're passing Starbucks. Here's a Starbucks. You get double stars." You know what I mean? So that's how it came about. And then obviously law enforcement's like, "Well, this is a pretty interesting way to track people and their whereabouts." So, yeah, the geofencing shit
So
drives me
no,
nuts.
they're saying that geofencing is the same as, so what they said,
Geolocation?
no, they said, so the one that I just read
Thanks, Slippy.
said that, yeah, it's like it says that, let me just wait.
Lana, do I have your Sleuthie? You got her? So I can shoot this over to Lana too.
It's yeah, geofence location data was protected. Let me just go back to geofencing for God's sakes. Okay, unlike a warrant, okay, geofencing is a technique of law enforcement that has increasingly utilized when a crime location is known but the identities of the suspect are not. Thus, a geofence warrant effectively works in reverse. Requesting a geofence warrant, they blah 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 blah. Google has been the primary recipient of geofence warrants in large part due to its extensive location history database. So it's the same as location history. So they received wireless carrier cell site location that tracked the defendant's whereabouts over the course of days. This form of data, prosecutors were able to produce a map. The Court of Appeals affirmed privacy interests. What year was that? Because I've been making that argument for so long. Oh, the Supreme Court reversed. Okay. What year is this?
All right. So while you're checking that out, so I think here's some thoughts that I have with respect to like the ramifications of this. I know that a lot of people were asking, do you think that the defense will now file a motion to continue the trial? I do not. I think if they
I think
did
they
that, they,
should.
I think, well, maybe if it's by way, well, they don't have to file a continuance if they file an interlocutory appeal, the matter's stayed, but
Either
she's got
way,
to
their entire defense has been completely disallowed, and they need to regroup and decide how they're defending this case and focus more on some stuff maybe that they didn't focus on initially.
I mean, that's I don't know if it's gonna fall on deaf ears with her, like, because I can tell you from the outside looking in, Andy was the big third party culprit guy. Brad was or is the
But
I'm
this is more
attacking.
than third party culprit. She said they can't mention the word ritualistic killing. I mean, can they mention the word ritualistic? That the scene was ritualistic? That it looked ritualistic? That it had some signs of, you know, somebody who had knowledge? You can't even mention that the crime scene speaks to somebody who has knowledge of Odinism. Yet there is no evidence in his digital history in his life that the government his state has been able to find that says that he has any knowledge of any of those things. I mean, like the fact that they can't mention that has nothing to do with a third party culprit. This
Wait,
is
who
it is
who
way
switched?
too.
Wait, who moved up? I was hold on. Put somebody just threw up catastrophe. I was don't change that off. I'm looking at that. I want to read this. Um I'm looking this up. Uh yeah, no, I get it, but here's the problem is that Gull does not believe and she saw the crime scene photos, like she doesn't believe that they resemble like I think that once McClellan made the argument that the defense misquoted the feds, the BAU is saying that they initially believed it to be ritualistic in nature. And then he quoted it as saying no, uh,
I don't
that
give a
they
shit
didn't.
what they think. If he's got an expert who says that it is,
I
and he
agree.
does, he has to be able to put that on.
I
She's saying he
agree.
can't even put that on. It doesn't have to anything to do with a
Right,
third
it
party
goes to
culprit.
weight. It goes to weight, not
But what
admissibility.
I'm saying is they don't have to mention a human being to discuss the fact that the scene looks like this and he has no, connection to that.
I agree.
Without even saying that there are other people who weren't properly investigated or who were, but that, blah, 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 that has nothing to do with third party culpability.
I agree, and I think that ultimately the question then becomes, has this ruling almost guaranteed if there's a conviction that there's going to be a retrial? I think that it does.
Absolutely. I mean,
I
there's
d
the
It's
she
like,
is
so
literally
everybody on the side of, like, Rick Allen's guilty, this is amazing, I'm so glad that they did this, what a
well, I
great
take
day
that
for
back.
justice.
Unless the other evidence is so overly
Correct.
whelmingly speaks to guilt, then it'll be a harmless error.
Like, if they have like, Rick Allen's DNA was found on one of the girls.
Right, or they decide that the court decides that his confessions were
Yeah,
very reliable and that they
yeah.
actually indicate he in fact confessed. Well, then all the errors that she does, except for denying him his right to counsel of choice, won't matter.
Right. Well, I mean, you and I were having the discussion this morning, and you believe that she cured that.
Yes, she did. I'm just saying if she did that again, like
Oh,
that's
all
right.
right.
Like that, those are what we call the structural errors where there is no balance of whether or not it's harmless, where it doesn't matter. I don't doesn't matter. And this is something that would matter. That they'd have to do a balancing test, and if the,
Oh yeah, yeah. If he's convicted, he's in prison, and then they have to appeal it, and
yeah,
then
it
the
takes a really
appellate
long
court
time.
has to do what Allison's talking about. They're gonna decide whether or not it's harmless error. And what she's saying is that when we start hearing the content of all of these confessions, and 61 is a massive amount of confessions. It should give everybody pause. It's like anybody who's admitting 61 times, I like is concerning. Like like anybody who's sitting here and pretending like that they could all be nonsense is not being intellectually honest. I mean, if Alice and I are handling this case and we found out that our client had said 61 different times that he killed the girls, I'm concerned. Like, I'm very, very concerned no matter what his mental state was. I mean, I don't think that there's a presupposition, and Alice and I have had this conversation prior to Richard Allen's case about confessions and about people's state of mind and when they've confessed and if they're psychotic. I mean, just because you're psychotic doesn't mean that you're lying and making it up. I mean, it could be that you're psychotic and telling the truth, or you're psychotic and it's both. That you're just
I think personally, we obviously don't know what the statements are. Now, if he makes a statement that is actually factual, that could not have been known otherwise, then that establishes reliability, right? But I think outside of something like that, that there's gonna be enough circumstances about his mental state at the time he made the statements, assuming that everything that we think is right and depending on the statements themselves, that an appellate or the Supreme Court would find that the only evidence they had against him were the statements, and that because of that, everything that they prevented him from doing denied him the right to a fair trial, denied him the ability to present a full and effective defense and new trial time.
yeah. Well, and here's the thing. There's really two arguments about the statement because timing is everything. In terms of reliability, there's certainly an argument to be made. Like, these were not confessions that were made in the interrogation of him initially. Okay. So at that point in time, he would have no way of knowing any of the facts of the crime scene. Whereas 7 months in, I don't know how many times Andy and Brad had spoken to him prior to that. I don't know what kind of details they gave him about the crime scene. I don't know if they were sharing information when they were going into the prison and saying, look, this is what it looked like. You know what I mean? Like if he
Right.
has knowledge of the crime scene because he's seen it and or
Right.
heard or like
Correct.
so
That
that
doesn't
goes
matter.
that goes to weight, right? So it's like timing is everything with respect to what he says and when he said it. So like that has to be taken into consideration massively. And again, that's going to go to weight. Like that's how she ruled on it. She's, because they're all coming in because there's obviously statements where we know because the defense is actually, that's the one of the statements we know the actual content wherein he says that I shot the girls. And we know that that didn't happen. So obviously he was making that up. So, like the defense is going to have to be able to show that, look, the state of mind of Richard Allen at this point had him all over the place. And then, to counter if there are factually consistent confessions that are made, you're arguing, okay, well, like we had gone through all the crime scene photos with him. We had gone through what had happened to the girls. Like this was all within his knowledge base. He knew it from us. We told him this isn't as if a cop just picked a guy off the street and he gave some kind of incriminating information that matched something that only the killer would know because there is an explanation as to how he would know it. So, yeah, I don't know. I don't know. Like I'm super super anxious to start hearing these things and what he's saying, you know. And it's like because the way that they like it, and never forget that the state completely changed their theory as to why he was confessing. Because initially, when the first time we ever heard about these things popping up, thank you, Shiraz. Uh the first time we ever heard of these popping up was at the first safekeeping hearing back in June of last year when I'm in court and I'm like, holy shit, they're saying he confessed. Well, like, we're going to hear what he's and their theory at that point was that the defense had dropped off papers to him, which I'm thinking are some form of discovery so that he's got the discovery and that he started eating the papers. And then right after that, that's when he starts confessing. Like that was their original theory that like him laying eyes on the discovery had caused this like just wave of remorse overcame him. And then he just started puking out the fact that he had killed the girls. So then it changed in July of this year. So when you've got Harshman, thank you, Sleuthi, for giving me his name, by the way, via text. Harshman, who's the cop who did all the listening to all the different hundreds of hours of Alan on the phone. And he says March 21st is when Alan finds God. And like after Alan finds God, then he starts having all these conversations with Kathy and his mother, wherein he's like, will you still love me? If I did these terrible things. He's like it's very important that I'm with you in heaven. I need you to forgive, so it's like that changed their entire theory of why he started confessing. Now, you and I know as longtime defense attorneys, I mean, it's not unusual for people to find God once they're in prison. Whatever the motive behind that is crazy. 61 does sound outrageous. It's crazy. It's a insane amount. Like, and people have speculated, I don't think it's 61 separate phone calls. I think it's 61 occasions, maybe within the same phone calls where he says it repeatedly. Oh, I killed the girls and Kathy's like, shut, what are you saying? Shut up. He's like, I did it. I killed the girl, so like we have no idea. I'm obviously speculating, but for it all to have occurred in that one period of time when he's eating his own feces, when he's running into cinder block walls with his head first, I mean, it has to give you pause, right? It has to make you concerned. Again, the question then becomes psychologically, why, if you're psychotic, why does that drive you to confess if you didn't do it? Like, why is the psychosis necessarily causing you to make false confessions? Is the question, and like the human mind's a mystery. Like, no one's ever going to really know that answer. Like, we just don't understand the human brain, you know? Uh, so I don't know. I don't know. It's like, let me see if I've got anything. Okay. So Crime Time Crochet, $5 hollow. Appreciate you. Uh, didn't she rule that they couldn't bring up him being abused in prison, so he couldn't use the abuse as an excuse for the confessions?
Is that in that motion lemonade? Can't talk about his treatment in prison? That's
Um,
if she ruled that, I mean, that's insane.
yeah, I don't know if she did rule that. Crime
Well, in
Time.
the motion to suppress ruling, she said that she didn't think that they established anything about his treatment that would have spoken to the reliability, but that I don't think she said anything about barring him from discussing it, but I don't know. I skimmed the thing.
Well, the people that have dug into Gull and kind of her overall rationale and demeanor as far as mental illness, she thinks mental illness is bullshit. Like,
Who?
Gull, like,
Oh,
she is
really?
not. Yeah, she she
Oh, it's not real.
she she is like, yeah, that's all. Like,
Fake
that's
news.
not her thing.
People don't have mental illness, and it doesn't
Right.
affect
People
the
like,
way they think or
like,
speak.
so like that, like having her background on that is
So
very informative.
the other I just wanted to say, because 'cause I've been looking at all these geofencing things, it's basically your location history, um,
Wait,
but
that's
not
not
like
geofencing.
not the real-time location history, right? Not while they're giving it to you in real time, so it includes it says, Google collects data, location data on numerous tens of millions of its users. It acquires and stores this data through one of 3 of its service, location history, web and app activity, and geo and Google location accuracy. Google only uses location history when it receives a geofence warrant. So it's location history in general.
What do you mean it's location history in general? I'm
It's
still
them
confused.
saying, "Google, use your location information and tell me who passed through this period in this time frame." And then they use that to generate it. And then on it, it'll say the distance. So I don't know if what they're saying, the state is saying, has anyone seen the
No,
geo
he should have said that then. He should have argued that Google gave us the areas wherein the geo fences are set up, and none of them are on Ron Logan's property.
or
Like
that
that.
Google's response had a a distance span of a radius of blah blah blah.
Well,
Like it
he
actually
he
said
made
it.
an argument that the spans can be up to like 5
No,
yards to
they would write it on there what it was. What do you mean can be?
that. I'm just telling you what McClelland argued.
Well, McClelland.
Yeah, you
I don't know
talk,
if
babe.
anyone's seen it because,
Well, how could anybody have seen it?
well, if they put it as an exhibit
They
in,
d they didn't, and we don't get the exhibits. Gull
not
doesn't
us,
allow
but the
them.
judge, she would know what Google, they put a radius, a distance on their response to say that an accuracy, information.
Alright, let me see what else we got here. So, I mean, ultimately, look, like this leaves two, Dr. Vonna K, $10 for Shiraz. Thank you for my membership. You've covered me time and time again. I can talk the talk, but am Apple tech illiterate, and DD is my favorite. Thank you. So thank you both, Shiraz, and thank you, Dr. Vonna. We adore you. We adore you. We adore you. We adore you all day. Um, so I think this is where we're left with this situation. The two primary things to think about right now are one, are they going to attempt to file an interlocutory appeal? If an interlocutory appeal is filed and she certifies it, that stays the trial. That means the trial will not go on in October
And
unless
it'll be on
somehow,
the defendant, so it won't nothing he can raise in a speedy trial issue because it's his
right.
request.
So that's one question. If that's like, because that's the only way this thing is like I hear your argument, and I'm not saying that they won't make it. I don't think she'll grant it. I think that she'll look at who their experts are. I think that she'll look and see that they've hired people to address the confessions and the phone issues. And I think that she's going to say that, I know where you spent your money. I know who your experts are, and I think you're ready. You've had almost 2 years, despite the 6 months I took you off the case. We'll forget about that though. And you're ready. You said you were ready. You said you like, she's going to use their statements that they were ready for trial in January and then again in May against them, that they wanted the speedy trials. She's going to turn around and use that as a sword against them if they try to ask for a continuance. She said, "Well, you're the ones who told me you were ready on two occasions. Said you were ready in January, and then you told me again you were ready in May. So what gives?" So, like, the only thing I think, like, she's not going to grant it if they just flat out, like, I don't think. And, so the question then becomes, will she certify if they
Mm.
decide to make the move? What you got?
This is interesting, I'd have to read so Google the courts deal a lot with whether, collecting geofencing information is a violation of all the Fourth Amendment rights of all the people who are being captured in there. So Google filed an amicus brief, or how do you say it? How do you say amicus? You say it differently, right?
Amicus, it's
An amicus brief, um, about the accuracy of their data. Google has attested to the accuracy of its location data that is significantly more precise than the location data considered in this other case. Um, One only needs to look at one's location on Google Map to know that the location data is remarkably accurate. At the same time, the margin of error is evident in the common scenario of realizing that your cell phone GPS position is off by a few feet, often resulting in your Uber driver pulling up slightly away from you or your car location appearing in a lake rather than one on the road by the lake. Google Maps describes this as follows. The blue dot shows you where you are on the map. When Google Maps isn't sure about your location, you see a lighter blue circle around the blue dot. You might be anywhere within the light blue circle. And then footnote says, "Oh, I might have to watch. I might have to read this." Um, it's to Google's an article Google put out. Anyway, they say importantly, the government does not initially seek information outside of the geofence zone, and if produced, it is the product of the technological limitations of the location data tracking. Um, a device which appears to be slightly outside the target's location's physical boundaries is the list of so it's just it goes on to say that it's pretty damn accurate. Um, and it could, sometimes they can capture things outside with the margin of error. Um, and then again, and in closing, they say, thus, the fact that warrants for location data have margins of error do not invalidate them. Only reasonableness is required, not surgical precision. A margin of error in light of the remarkable accuracy of Google location data is reasonable given the nature of the evidence between being sought and what is possible within the technology at issue. But again, I don't know if there's something specific there in their area or that in Google's response that has made the margin of error so much greater, because he says it could encompass the whole town, but yet it didn't. Not everybody's phone was on that map. We're talking about
right.
three phones. So,
Yeah, I don't.
I hope they do file an appeal. I hope they do ask for time. I don't know what they have. They could have so much other stuff that this doesn't matter to them.
Wait,
I
that has
I
to matter to them.
I would file an appeal. Me personally, I would try to especially because if they don't, they have waived the issue on appeal. So don't want to waive issues on appeal. I mean, I'm not 100% sure because I don't know Indiana's interlocutory appeal law. There could be something that says you don't waive an issue just because you don't seek an interlocutory appeal. Because I don't think they want everyone and their mother trying to. So I take that back. I don't think they have to file an interlocutory appeal to preserve the issue on appeal.
Yeah, I think that they have to.
I still think they have to, right?
Like,
Because their hands are tied.
really, again, more for to me, the geofencing stuff is way more upsetting than the third party culprit stuff.
I don't like calling it third party culprit, Bob. It's literally preventing them from even talking about what the crime scene looks like and how it speaks to uh, a motive that this defendant doesn't have, or that it speaks to someone with knowledge that this defendant doesn't have.
yeah, I mean, it's both. I mean, they named 6 or 7 individuals. And look, I mean, if you're asking my honest opinion, like I would have been leaning into Ron Logan way more than these guys. It was his property. They searched his property. Like it makes sense in terms of the girls not being there when the search takes place and then being there in terms of access to the property. I mean, he had a history of violence. He just made sense in a lot of different ways. And they certainly liked him. He lied about his out. Like he just had a lot of like smoke there where I don't know if it's fire or not, but like in terms of third party culprits, which completely alleviates the Nexus issue in terms of could he been there? Could he have been to the location? Yeah, he lives there. Like his pot, you know what I mean? And he was certainly one of the first guys that they looked at. He was certainly the first guy that they got a warrant, to search his property. So, I don't know. I don't know. Um, Well, Karen, I've been saying this for months, 2 months, easy. I'm focusing on attacking the timeline if I'm the defense. To me, the one thing that's still in, as far as I know, is the phone, Libby's phone that inexplicably turns back on or connects to the tower at 4:33 a.m. when 15 messages then flood onto her phone that were sent 11 hours earlier, knowing that AT&T was pinging that phone the whole time. I believe, as far as I know, AT&T never stopped pinging the phone. And I have talked to multiple experts that cannot give me a reasonable explanation why for 11 hours, if that phone was in the same position that entire time, why it wouldn't have connected one time with the tower during that entire period of time. Like no one can give me an answer that makes any sense. I'm like, other than the phone was turned off or not there anymore, which means that somebody was there at 4:30 in the morning, which I think probably alibis Rick Allen out. I don't know.
Or do you have any super sticker questions or whatever?
Let's see. We've got Crime Time Crochet, $10 holla. Appreciate that. Migraine. Sorry. Since she suppressed it, can they not use that as reliable proof for why he confessed? Since they can't cite back to what is suppressed unless he goes on the stand, I suppose. It's an interesting question. So what she's asking essentially is how are they going to get into evidence the conditions of his confinement?
Well, they're gonna have to put on the person who he gave the statements to, and they could ask it of that person.
Well, what happens if it's his wife and his mother and the warden and
Well, the
the
warden, yeah, right? The warden can speak to it.
Yeah, and these suicide companions or whatever they call them, the inmates, the fellow inmates that were
Right.
right. You know, it's like,
They can speak to it.
yeah. But I mean,
I
like they can speak to what? Like how far afoot is she going to allow them to go in terms of the conditions of the confinement? Because we had the same issue in Garcia. Like we had the
He didn't make any statements, though.
I, I know that, but like
Well,
in
you would have been
terms
able to
of,
get his conditions of confinement in if he had made a
but I
statement.
wanted to explain like why our client looked like Ted Kaczynski and was sleeping through his death penalty
He
trial,
should
and
have
that
let
was,
you. They and
yeah,
I'm, you know,
yeah, um, yeah, I don't know. Yeah, like McClellan doesn't even understand the differentiation between tower pings and geofencing. Like the guy doesn't even know. It's just so crazy. It's crazy. It's crazy. So yeah, I think that they're going to have to file the appeal. I think it's dangerous not to. I don't know. I think it would be ineffective almost for them not to try, like for those three issues, for what you're arguing in the sense of what the crime scene looked like. I think that there is a nexus between their third party culprits, and the geofencing thing is huge to me. You know, like I just can't think of a case where you have this much of a nexus, which I consider. Do you think that there's no nexus between these guys?
I think there's one hell of a nexus,
I think there's a
personally.
massive nexus. I think there's a huge nexus with Ron Logan too. Like, how can she say, like, I don't know if she took it as because the defense didn't make any kind of argument other than to enter Ron Logan, the search warrant against Ron Logan's property or for Ron Logan's property into evidence as the totality of what they argued as Logan being a third party culprit potentially. They didn't make any kind of argument for Kagan Klein and his father, Tony. They put on a whole thing. Like they put on witnesses. They're like, the Kagan had made a statement that they were down on the property and that he was waiting and his dad came back and he was wearing bloody clothes and they threw shit they were in a red Jeep, like threw shit in the river that his father had used to kill the girl. I mean, he basically confessed, and they're like, well, look, we looked at all the available video, and at no point did we ever see a red Jeep in that area. And beyond that, we have both of your phones at your residence in use during the time that you claim you're there. So for those reasons, they cleared them. Um, Logan's dead. Like, blame the dead guy always. Like, if you have the opportunity to blame a dead guy who can't like defend himself, why aren't you blaming the dead guy? I don't know.
Yeah, for sure.
Yeah. So, all right. It's been a good live. It's been a
Yes,
good
so at
live.
the end of the day, my position is that her ruling categorically interferes with his ability and his right to present a complete defense.
I agree completely. And at the end of the day, um, and the other part of this that's being lost is that Gull gave them money to hire a bunch of experts that they're now not going to be able to put on the stand. Like a
Right,
lot.
so why would she give him the money for that? Doesn't even make any sense. They
I
need
don't
to
know.
file a motion to clarify her ruling and to make sure that what she is saying is not only that it doesn't rise the level of 404B, which is again the only time you need to show uh this heightened evidentiary basis, heightened requirement that they're actually a third party culprit is to get in evidence that you wouldn't be able to otherwise get in. But she's actually saying they can't even mention these people as being people investigated, as having a possibility to.
Well, that's what Lana's asking here. Question. So they are not allowed to ask them about persons of interest in the case and who they are and how they ruled them out. I mean, it took
Yes,
5
that's what I'm
years to arrest.
saying.
I know. Like you guys are both right. It's insane.
So
Like they're not like it's this simple. She is not allowing them to put on any kind of defense.
But is
That's
that what
it.
she's saying? That's what I'm saying. We saw the difference in Reed. They're allowed to get all that stuff in, but at the end of the day, the judge
But
said,
Judge Bev like said that she's going to allow for them to develop it on cross-examination. It's a completely different ruling. She unequivocally said that I'm going to allow you to get into this stuff on cross-examination. I'm not allowing you to present it as a defense, but I'm certainly going to allow you to ask it, because it goes into the integrity of the
of the
investigation.
investigation. Right.
I mean, like, how is she barring them from doing that? She has essentially barred them from putting forth any kind of defense
Yeah.
other than reasonable doubt. That's it. Like, that's all you can do. You can challenge the evidence they have. You can't put forth anything else that could potentially confuse the jury that it might have been somebody else. It's crazy. It's a crazy, crazy ruling. I think ultimately for all of those that are cheering about this ruling, thinking that justice, like you're gonna be ruining the day when this thing gets kicked back for a retrial because of this decision that she made in this court order. That's what I think. Short of this thing going up to interlocutory appeal, I would feel so amazing if it goes up to the appellate court and they're like, "What? You can't do this. What are you doing?" Because it's like the concept of like I don't want to hear any like Judge Gull is the goal for this trial. That is in stone. Nothing's happening. No OA. I don't see them filing another original action. Like to me, what Allie and I were saying a long time ago is they should have filed a interlocutory appeal. Now their argument then is going to be the same argument now, but they got to try. They can't just assume that she's not going to certify it, and they have to try to do it. So, as far as I'm concerned, if their wives are listening, which I know that they do listen to our show, tell the guys that they got to file an interlocutory appeal. Like stat, got to do it. Trial is nigh. It's coming. It's like you're on the precipice, like right now. So, all right, mods, we love you. We thank you. I would go a little longer, but we got an hour drive to go see Scarlett crush some volleyball. Our little mighty might. I have to admit, I'm having a lot of fun watching the volleyball games. They're definitely more fast paced than the softball. So, like, I'm enjoying it quite a bit. I hope that I was able to get Allie and I to your questions. We will do another live on Delphi in the very near future. I am trying desperately to get. I've had a couple conversations with who I consider to be pretty knowledgeable guys about geofencing and also just the phone tech stuff. I'm trying to get him to come on with me so he can explain it to us like we're 5 years old. All the phone tech stuff that I just don't have like a firm grasp on because I'm a lawyer. That's why we hire experts. So I'd love to be able to do that. I am perplexed by the whole 430 phone thing. I don't know why everybody's not talking about that. Am I the only person in the world talking about attacking the timeline?
No.
Because like, am I in crazy world? Like, I can't be, right? I mean, attack the timeline. They don't have a time of death. The ME did not establish a time of death or even a window. The ME did not take the temperature of the bodies at all.
All right, we got to go.
All right, you guys. If you got to dip off, dip off.
Okay. Bye, guys.
All right, bye. All right, you guys, mods, thank you so much. I adore you. Dizzy, thank you for all you do always. Dr. Vonda, thank you for that late $10 hollow. I appreciate that. Oh, I almost got a venue. I always forget. I need Jay here to remind me about my venue. Dixie Parrish, thank you so much. I did get your $10 Venmo. Little something for your pocket. Thanks for keeping us informed. Thank you so much, Dixie. I appreciate that. I always love the Venmos. The Venmos are amazing. So tomorrow I'm going to go live. I'm not sure what I'm going to do yet. There's many things. I'm contemplating maybe covering the woman, the murdering wife trial that's starting next week. Maybe. If I do decide to do that, I want to do a primer on that case. It's a weird one. It's a really weird case. It's the woman, the woman apparently was on her husband's Facebook for years after, while they couldn't find the body, like posting updates. She then turned around and I think tried to say that her 7-year-old daughter is who killed the father, that she shot him. So it sounds like it could be kind of a weird, interesting, disturbing case. So all right, you guys have been amazing. I appreciate you. And we'll see y'all on the flip. Take care now. Because remember, without y'all, an old man talking about a lot of cases, maybe too many.